This courtroom hearing may seem routine at first glance, but it quickly reveals a deeply disturbing story of betrayal, violence, and a judge who refuses to ignore the human cost behind the charges. Today's case centers around Alfredo Campos, a defendant facing a serious felony, assaulting a family or household member with a prior conviction. That alone already puts him in dangerous legal territory, but the facts behind the case are what truly shake the courtroom. According to the reports, the very person who helped him, someone who picked him up from custody and brought him home, became the victim of the assault. As the hearing unfolds, the judge doesn't just accept the plea bargain quietly. Instead, the court digs into the reality of what happened and why. The result? A powerful courtroom moment where the judge calls out the behavior directly and delivers a sentence meant to break a dangerous cycle.
Alfredo Campos, is this a plea?
Yes, Your Honor.
All right, can I have a file stamp for a plea, please? Court is calling 2025 CR 002720 State versus Alfredo Campos. Could I have parties announced?
And for the state of Texas. Renee Munoz on behalf of Mr. Campos.
All right. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Is there an application?
No, Your Honor.
All right. Mr. Campos, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, state will proceeding. Additionally, Your Honor, state will waive the repeat offender enhancement. Also no objection.
Okay. All right, did you review the document entitled court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right, in count 2, you're charged with assault, family household member with a previous conviction. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to 10,000.
What you're hearing right now is one of the most important parts of any felony plea hearing, the judge formally explaining the range of punishment. In this case, the charge is assault against a family or household member with a prior conviction, which under Texas law elevates it to a 3rd-degree felony. That means the defendant could face anywhere from 2 to 10 years in prison, plus up to a $10,000 fine. The judge is also making something crystal clear here. Just because the defendant has negotiated a plea agreement with the prosecution does not mean the court must accept it. Judges have the authority to reject plea deals if they believe the agreement doesn't reflect the seriousness of the crime. Another key moment here is the defendant waiving his constitutional rights, the right to a jury trial, the right to confront witnesses, and the right to remain silent. Once those rights are waived and the plea is entered, the case moves rapidly towards sentencing.
$1,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. State is proceeding on count 2. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor. I did mention that when you get to the stipulation.
Right. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
And you're not allowed to be designated as primary custodial parent?
Yes, sir.
Right. Knowing that, do you still wish to continue with this plea?
Yes.
Right. Did you review the waiver of appeal paragraph with your attorney?
Yes, sir.
Did you understand it and sign it in both places? Did you understand it and sign it
Yes.
in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Judge.
Then to the offenses charged, how do you plea in count two? Guilty, not guilty, or no contest? State any evidence?
Representative State into evidence, State's Exhibit 1 with all attachments.
No objection.
Right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're asking the court follow the negotiated plea bargain agreement, Your Honor.
All right. So what is wrong with you?
This is the moment where the tone of the courtroom shifts completely. Up until now, everything has been procedural, legal paperwork, formal rights, and the mechanics of entering a plea. But once sentencing approaches, the judge steps back and looks at the human story behind the case. According to the police report, the victim went out of her way to help the defendant. She picked him up from custody, brought him home, and tried to support him. And yet, the report says that later the same day he allegedly struck and choked her. That's why the judge is pressing him so directly with questions like, "Do you love her?" and "What is wrong with you?" These are not rhetorical jabs. They're an attempt to force the defendant to confront the reality of his actions. Situations like this are unfortunately common in domestic violence cases, where victims sometimes file affidavits of non-prosecution, asking the court not to pursue charges. But as we're about to see, the judge isn't letting that erase what the evidence shows.
This is a person, for whatever reason, decided to pick you up from custody when maybe she should just let you stay in there, for whatever, and let you just stay there. She takes it upon herself, and I'm sure she paid your bond, and she picks you up and brings you back home, and then you beat her up. What's your issue?
I think you should.
Yeah, I mean, you do. Because somebody do you love her or do you claim to love her?
No.
No, you don't, because that's not the way you treat people you love. She took it, probably money from her children, to pay to bond you out, and then, all right, let me tell you what's in the police report, and you tell me what's incorrect about this. I asked victim what happened. Victim stated the following events occurred. Since Wednesday, she went to pick you up from the jail. She stated they were good, no problems. Later that day is when the defendant began to strike and choke the victim. So this is where we are.
Or I don't know if, I think he just got a little bit tangled up. I don't know if he bonded out or if he was just released at that point, and then she picked him up instead of the bond. I think that's where he was a little confused.
I was just confused because I was released from ISF, not from the county jail.
Oh, okay, so there was no bond posted. Okay, that's what I think he.
So here's my question. Is the reason for this offer because the complainant does not want to participate and has filed an affidavit of non-prosecution? All right. So she's filed an affidavit of non-prosecution, even though I'm looking at the photos, she has a black eye, she has bruises on her arms, and she took time out of her busy schedule to come pick you up from wherever you're incarcerated. So for some reason, she's attached herself to you, but I'm going to try to break that cycle today. So I'm going to sentence you to 3 years in prison. There'll be credit for any time served. There's a $1,500 fine. Time and money is not running concurrently. There's an affirmative finding of family violence. There's to be no contact with Ana Maria Hermio, aka Ana Maria Gonzalez, and you're not allowed to reside in any residence with minors. Do you understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed this plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. We can go off the record. Here's the thing. Don't get involved in any other relationship. Don't contact her. If you love her, the best thing you can do for her is not contact her, because you're not any good for her. And until you figure out why you feel the need to put your hands on people in anger, you should not be in anybody's relationship. Here's my advice to you. Get an orchid. I always tell people that, and this is why I tell people to get an orchid. An orchid takes a lot of patience. When you get it from the store, it's beautiful. They all have them all with the flowers bloomed on it. They will give you directions. Those directions don't work. I learned you're not supposed to put ice cubes in them. But if you can let the blooms fall off of that orchid and keep that same orchid and get it to rebloom, you may be ready for a relationship, because with orchids, you have to learn patience. You understand?
This case is a stark reminder of how the justice system handles domestic violence cases, even when victims themselves may try to withdraw from the process. Despite the affidavit of non-prosecution filed by the complainant, the judge relied on the evidence in the police report and photographs showing visible injuries. Ultimately, the court accepted the negotiated plea and sentenced Alfredo Compost to 3 years in prison, imposed a $1,500 fine, and issued strict conditions including no contact with the victim, a permanent family violence finding, and a prohibition on possessing weapons. But what stands out most in this hearing is the judge's closing advice. Instead of simply ending the proceeding, the court urged the defendant to reflect on his behavior, and even gave an unusual metaphor, telling him to learn patience by caring for an orchid before attempting another relationship. It's a rare moment where legal consequences and life advice intersect in the courtroom. And now, we want to hear from you. Do you think the sentence was fair given the circumstances of the case? Let us know in the comments below. And if you found this courtroom breakdown insightful, make sure to hit that like button, share this video with others who follow real courtroom drama, and don't forget to subscribe for more jaw-dropping courtroom cases just like this one.